Need so much time. Yes.
Item 1, your lordship, the order dated 7/8/2025 by annexure 1, page 8 and 9, has not yet been complied with, my lord.
Not complied.
No, my lord.
Issue police notice. Issue emergent notice through police. Returnable in 2 weeks. Item 2. Item 2.
Order. Dated 10/9/25 has not yet been.
Same order.
My lord, in spite of your direction, because earlier.
Item 3.
Notice is not issued.
Item 3.
Item 3 on behalf of Mr. Samudra, my lord. Kindly pass over.
Pass over. Item 4.
Please, my lord.
My lord.
My lord, yes, non-compliance of the order. My lord passed on 18/8/2025, whereas my lord also for compliance of the order directed. Last line, my lord, may I read out that if decision is not taken within 8 weeks, it is open to the petitioner to move an appropriate application for taking punitive action against OP number 2, which.
All right.
Sir,
Same order.
oblige, sir, oblige.
Next. Item 5.
Item 5, my lord, order dated 17/9/25 not complied with.
Same order.
Oblige.
Sorry, my lord. He is not his item. He has told that your lordship's course item 3 is the affirmative. I have wrongly I have.
Which is 3? What is the order?
Order dated 25/8/24 but not acceptable.
Not complete. 25th of August. How much time was given? 6 weeks. Last same order. Next. Item 6. What is the order? Go to last paragraph. In all such matters at admission stage, go to the last paragraph. 8 weeks. It's the same order. Next. Item 7.
My lord, the order dated 10/11/2025 in WPC number 30750.
What was the time given? Timeline is
My lord, 4 weeks.
same order.
Oblige, my lord.
All police notice. Yes. Item 8.
My lord, may it please. My lord, 28/10/20.
Not telling how to put. The police is directed to serve the police scrupulously and submit service report immediately, very which punitive action may follow against the concerned police. In all matters below it.
My
Yes.
lord, 28/10/25 order has not been complied with.
Yes.
My lord, I have another prayer, my lord. My lord, the contender name has been wrongly mentioned. Can I be permitted?
Learned counsel appearing for the complainant seeks leave to rectify the name in the cost title. Since mistake is by inadvertence. First, leave is accorded and the complainant is permitted to rectify the cost title.
Grateful.
My lord, item 6, my lord, I was mentioning matter just came late. Item 6.
6 we have issued notice. Police notice.
Grateful.
Yes.
My
Item
lord,
9.
I beg pardon, my lord. In the prayer, one mistake has occurred that opposite party number 1, it has written as opposite party number 5.
Counsel for the petition. Which is that matter?
My lord, item 7.
Item 7.
Yes, sir.
Counsel for the petitioner seeks makes oral application seeking leave to rectify the mistake in the prayer column by mentioning the rank of the parties proper. First up, leave accordingly. Yes, thereafter issue police note. Yes. Item 9 is complaining to rectify the mistake immediately.
May I please, your lordship? Your lordship, 8/9/2025 order is not compliant.
Police notice.
And your lordship, one more prayer. Your lordship, in contempt, the contender number 2 is transferred. So maybe kindly change the name of the contender number 2. He has been transferred.
It cannot be changed that way because there will be an affidavit. So that affidavit is based upon what is already mentioned in the cost statement. Therefore, for that you have to make an application. Let notice go. Let us see afterwards. Yes, police notice. Yes, next.
Item 10.
Yes. What is this? Modification of order dated?
Yes, modification force.
What the modification they have sought for? Go to the application. Modify the application. What modification? They are not dated. The modification they have sought for. The mirrors have all the one has been instead of the 2 and line 7 of the paragraph. Application supported by the affidavit seeks rectification of certain mistakes which have been specifically mentioned in para 5 of the I first half. Application is supported by an affidavit and mistakes are apparent, errors are apparent. First half. Therefore, this court exercising ex debito justitiae jurisdiction grants leave, allows the application and directs the registry to rectify these mistakes as indicated in the said paragraph and issue a fresh copy of the order if applied for. Okay. Next.
Item 11.
Item 11, that is Mr. Samantra is matter, madam, and passable. He is for the opposite party.
Item 10.
No.
Well, Mr. Passover on behalf of Mr. Mohanty.
My lord, I'm on virtual mode, Miller. The
Yes, sir.
identical matter in connected matter, the order has already been passed, Miller. That is read petition number to 20518. I number is 21.
Recall order I rejected in that.
30 of 2025.
In that.
Yes, and I granted liberty to, I am granting liberty to file review, Miller. That was the order, Miller. The day before yesterday, the read petition number. Yes, Miller.
And supported by affidavit, the recall of the order whereby this petition was disposed of in favor of the petitioner. First, counsel for the petitioner finds out that there are errors apparent in the record, and therefore the said order needs to be recorded. First, next paragraph. In WP number
20518.
Date of which year? You have to tell full name.
16, this is the order.
2025, Miller.
25. Similar application. And the same came to be negative, granting liberty to the applicant to seek review of the judgment if the case fits into order 47 rule 182, rules 1 and 2 of CPC 1908. First, therefore, the same course, the same weight this application has to meet from the principle of merit, there being no divergent circumstance. First one, in the above circumstances, the application is dismissed with liberty to seek review as observed above. Yes.
I may be pardoned, my lords.
Yes.
In item number 10, copies were not served on me.
10.
Yes, my lords.
10 what we have done?
Your lordship has allowed a modification, but
No, only rectifications. Dates and other things are.
My lord.
This will give the copy now.
My lord already served to that.
One more.
My lord.
Don't but print that order.
My lord, today already
The
served.
reports, you have to follow the court's order. Don't waste time on that. Give one more copy.
My lord.
Yes.
Yes, sir.
Print. Next.
Maybe excuse. Well, a traffic jam, Lord, I will be late. Item 11, Lord.
11. Settle.
Discuss lordships were directed. There is a cost of 50,000 was imposed by lordship. I had filed an application making an apology. The lordship had directed to make payment, then come lords. We have made payment since 17/12/2025.
Who is your opponent?
Because Mr. Potti was there. Last time he had assured lordship that once the payment made, he will not pursue for that. In both the cases, we paid the payment immediately after lordship.
You bring your friend.
No, sir.
Yeah. Generally, costs when I impose, I do not record.
No,
the
lordship
order
has said that because
I want to threaten the officials by costs, heavy costs, if possible, by inflicting injury wherever possible. Therefore, generally, I do not entertain such applications. Anyway, bring your friend, let us see.
yes,
Otherwise, no official will work in the state. We have seen enough now.
Yeah.
Last 7 months I have been here.
yes,
No
sir,
more,
I-
They
nothing.
must
Yes.
comply, your lordship. They must
That's
pay
what-
respect to the order of the.
No respect for the court. Therefore, we will not show respect to them also. Yes. Item 13.
Yeah, please, your lordship. My lord, your lordship, may kindly see order dated 17/12/25.
17.
17/12/25.
17, 12.
The lordship directed as an interim measure
There is no such order.
staying. Oh, 13, sorry.
13.
I am 14.
Yes, madam. Pass over. Pass over. Item 14.
May I please also? My lord, your lordship may kindly see order dated 17/12/25, wherein your lordship directed, I have quoted the order page 2 of the IA interim application. Your lordship,
Where is the next page?
section 19 has been mentioned in the order.
Page 1 is there. Page 2. Where is page number 2?
That quoted portion, the lordship direction is there. The lordship directed that pursuant to annexure 19. Actually, that would be annexure 18 because I have impugned that letter.
Annexure 18.
My lord.
That
It
was
would,
questioned.
no. Your lordship directed that 50% have been deposited. Paragraph well, page 2.
Here, instead of annexure 19, it should be 18.
Again, my lord.
In the operative portion of the order dated, go to the
16/5.
16, not 5. 16/5. 16/5/2025. No, our order of the court.
My lord,
Date.
17/12. Sorry, I 17/12.
In order dated 17/12/2025, entered in the subject writ petition by way of interim measure, comma, the impugned order at annexure 18 ought to have been stayed, whereas what is stayed is annexure 19, comma, tells the counsel for the petitioner. First up, he requests the court to rectify the mistake and issue a free copy of the rectified order if he applies for one. First up, there is words in this submission. Next paragraph.
My lord, your lordship, one more. The time may be extended because your lordship have fixed
In the
to.
above circum, why time should be extended? No, that is no ground.
My lord,
You knew what is the order state.
my lord, I am prepared to deposit because
That
of
makes no
this
sense.
19. 1 month time, your lordship granted already
No, not
in the previous order.
in the, therefore will not.
Let
grant.
it be within 2 weeks, I'll deposit the entire amount.
You knew everything. This is only a rules not to pay.
No, my lord, I am sorry to say, my lord. Because of this correction, I am not.
Submission being paid, comma, the order dated, impugned order dated so and so shall be construed as staying annexure 18 and not annexure 19. First up, the request for extension of the period for complying with the condition is rejected. Next, item 15.
My lord, no.
No.
Tomorrow is the last date, my lord.
Let the client die. Yes, next.
I'll deposit tomorrow.
If you want to do it today.
Yes, sir.
Item 15.
May I please, your lordship? Lordship, they have already complied to the order. So I suggest seek your lordship leave for the withdrawal of the contempt.
Counsel for the complainant submits that the order in question having been complied with, comma, the petition has become infructuous and accordingly it will be disposed of. Below, ordered accordingly. Yes. Ordered accordingly, and petition is disposed of. Complaint is disposed of. Next, item 16.
My lord, for person to a lordship's order dated 19/12/25, notice was sent.
But noting your lordship may kindly see, unsub notice issued on OP 8 to 14 return. Postal tracking report at flag B, so I.
So what you want to do?
My lord,
You have to take steps.
my lord, one is the main contestant.
If you leave them, I will say that you have deleted them at your risk and therefore no fresh steps.
Yes, my lord, the others.
Give memo.
Yes, my lord, I am giving him.
Give the paper.
My lord, I will only confine to one because he was the.
Already I have said that. Counsel for the petitioner, the review petitioner submits that the unserved respondent OPs, namely OP numbers 9 to 13. No, which OP?
My lord, 8 to 14.
8 to 14. Not being either necessary or proper parties in the light of apex petition in Rajia Begum, 58 Supreme Court so and so, he gives up the claim against the said respondent and confines the challenge only qua OP number
1.
1.
Yes, ma'am. He was the petitioner before.
But 1 to 7 are served now.
1 to 7 is served, but 2 to 7 are state, madam.
Confines the petition to the to other OPs. He has also filed a memo seeking deletion of OP numbers 9 to 13. Next, the request is accorded, and accordingly, OP numbers 9 to 13 are to be
8 to 14.
8 to 14 are to be deleted. 8 to 14. Deleted by amending the cost table right now. Yes.
My lord, one notice is sufficient. One is now not appearing.
Notice to OP number 1 is that sufficient in view of service report of the postal department. Correct? Yeah. 2 to 7 are represented by learned AGA Mr. Panda. Yes. Item 17? Sure. Next.
Your lordship may fix it for any
Call
time.
the next. Call the matter when this judge sits single.
Yes.
Item 17, Miller, and I heard the respondent. I have appeared. But the copy of the CMP I have not. I don't have Miller. So let me
give one more copy.
It was
one more copy.
Along with the, yes, no, I will supply.
So it was issued, but CMP copy. But I
you know. You don't.
Yes, yes. No, I am.
Still you want to argue?
No.
Take that. Registry to furnish a copy of the CMP along with all the records by way of Xerox, photostat copies. Copy to the council appearing for
Respondent number 1.
Respondent number 1.
Only respondent.
Only opposite side.
Response. Call this matter. We got when same of.
Another prayer, Miller. Let it be taken off.
Interim order to continue.
So interim order was on the last occasion. It was not extended.
Yes, order that was not extended on the previous occasion is extended since there is no change of circumstances.
No,
Existed when the interim order was granted.
Yes,
well, lordship, while the matter was before the previous bench, and they made a mention that the court, court was inclined to therefore court transfer the matter. So along with another matter. So
this matter along with
this CMP 406 of 2025.
That you have to seek, call this matter along with so and so after obtaining necessary orders at the hands of Hon'Ble the Chief Justice as requested at the bar.
So
item
interim order already there.
Item 18.
Right now, I have received the SOCAS. May be permitted to serve, but the sum and substances, it is to be complied only 4 weeks time is required. I am serving the copy.
No time will be granted. We have already fixed that time. Did you
only for a certain new facts are there for which for the needs of compliance in the same only 4 weeks, my lord. For that I am filing.
No. No question of granting. It's the time fixed by the writ court. This is not the writ court. This is a contempt court.
Yes, my lord.
Therefore, you have to make application in the writ petition, not here. This is a contempt court. Contempt court exercise under the provisions 10 and 11 of Contempt of Courts Act 1970. This is not a writ court.
There are certain facts which needs compilation. Where it my lord, the language is my lord, only to comply with the order of your lordship.
That argument will not. There is order. If the order says your officials to jump from the first floor, they have to jump.
Yes, ma'am.
Unless they get it modified. That is the contempt. Otherwise, what is the meaning in court orders? If somebody is to be hanged by the court order, he should be hanged. That's all.
My lord, other day my lord has given that illustration. My lord, may I pray only?
No.
We have prayed for 4 weeks. Let it be 2 weeks, my lord. We are complying. My lord, we are in the process. Not that we are want to modify it or something.
Issue arrest warrant against the OP numbers. OP numbers 1 to 4 for not reporting compliance within the stipulated period in terms of order dated
4/8/2025.
4/8/2025. Whereby the WP number 17781 of 2025 was finally disposed of. First now. Next paragraph. The police to produce the said OPs on the give next Friday will be Friday is not possible. Next Thursday, put a date. Thursday, working. Yes. On 20, you put it on 27th. No, 22nd. On 22nd of this month. This month. Next paragraph. However, in the meanwhile, if the order is complied with, and report is submitted to the Registrar General, marking a copy thereof to the complainant by speed post, the arrest shall not be effected.
Deeply obliged.
All right. This is the way.
We'll make it.
Next.
Item 19.
Lord's order has been complied with. I have filed a memo. Lordship kindly
First, the complainant submit that
kindly refer this memo.
Filed a memo dated 16/1/2026 which reads as under. Next paragraph. In terms of the memo, complaint is disposed of. Next paragraph.
Item 20.
The Lordship's order dated 8/8/25.
Item,
Yes.
item 20, my lord. May I say, in this matter, appeal has been preferred.
Appearance of Lordship
And,
order dated
My lord,
28th
this
November.
order is there, my lord. May
It states.
no, my lord. And though delay was there,
Yes.
notice was issued and it has been date fixed. Because of the non-availability of the bench, it could not be. My lord, this is the order of the Honorable Chief Justice.
There is no step. This court wide order dated
8/8/25.
8/8/2025 disposing of the writ petition in the operative portion has observed as under. Next paragraph. One more sentence. Learned counsel appearing for the complainant submits that the order has not been complied with, there being no justification whatsoever for non-compliance. First one. Next paragraph. Learned the AGA appearing for the OPs or contemners submits that the state has prepared writ appeal number 1742 of 2025 and notice has been ordered by the division bench of this court on 19/11/2025 and therefore the contempt proceedings be halted till the next stage of the said appeal. First one. I do not subscribe to that view since the coordinate bench has not granted any interim order of stay or of any reprieve. First one. Next one. In the above circumstances, issue arrest warrant against the OPs.
OP1.
OP number 1. Only one.
Only one.
OP number 1. And produce her before the court on 24, 26, 27. 22nd. 22nd, to show cause as to why she should not be committed to prison, civil imprisonment.
Great.
Next paragraph. However, in the meanwhile, if the order in question is complied with, subject to outcome of the writ appeal, no coercive action shall be taken against OP number 1. Next.
Item 21.
Yes. Tell registry to keep one room vacant so that we can put them in that room itself. Yes.
Item 21.
May I please?
Yes.
Here, my lord, compliance report has been filed.
Compliance report is filed.
It's my lord.
Show that.
24/12, my lord.
Where is the compliance? What was the order? What is complied with?
This is order dated 37/2025. For disposal of this representation, my lord, which has been taken care of and it has been disposed upon 22.
Yes, brother. Challenge that.
Last occasion, your lordship also issue information from the council of the opposite party, my lord.
Compliance report is affidavit is filed. If you are aggrieved by the order taken passed, you challenge that. I will give liberty to you. There is no contempt. Because they have passed the order, because we threatened them arrest.
Only simple matter, my lord. Only incremental matter relating to
The
only
complaint alleges violation of the order dated 37/2025, whereby complainant's WPC number 20361 of 2025 was disposed of. First off, the operative portion of the order reads as an. Next paragraph. After service of notice, learned AGA appearing for the OPs submits that pursuant to subsequent order threatening arrest and detention of the OPs, the order in question has been complied with, and accordingly the order came to be, the subject representation came to be disposed of on which date? Compliance,
This is my lord, file on 24/12/2025.
24/12/2025.
And the representation disposal of date, my lord, kindly have a 22/10/2025.
22/10/25. 22/10/25.
Yes.
Compliance affidavit is also filed. Sold to by affidavit is sold to by whom? For the author of the order.
Yes, my lord. This is DO, my lord, District Education Officer.
Who was supposed to dispose of the application, representation?
DO.
By the
OP number 4.
Who was mandated to dispose of the said representation. First, in view of the above, next paragraph. Wherever I say in view of above, it should be different paragraph. In view of the above, the complaint is disposed of, dropping the proceedings, reserving liberty to the complainant to take regressal against the order in question, whereby the representation came to be disposed of. First of, in that connection, all contentions are kept open. Next.
Item 22.
Affidavit is
Happy, you do not give why government education, we will tell them not to give any copy to you.
No, my lord.
This is third matter. Within 1 week.
Right now.
Then we will tell them not to serve any copy on the government. Next.
Item 22.
Item 22, your lordship. In the meantime, they have given me appointment in the post of assistant professor, your lordship. But I have 25 years of experience, your lordship.
That you have to check. There is compliance.
It is
yes, in fact,
it is not my appropriate post, your lordship.
Listen to me.
Yes, lordship.
Law of contempt by James ECV Superlaw. It quotes a judgment of the apex court, where the direction was to pay certain sum of money, a specified amount. But they did not pay specified amount, but they paid 1/10 of that amount. The apex court dropped the contempt proceeding, holding that there is compliance. Therefore, if you are agreed, take up the challenge to that order. We reserve all contentions in.
I will challenge, but the lordship order was there to post me in an appropriate post.
Appropriate. According to them, that is appropriate.
But it is not my appropriate post, Your Lordship. I have 25 years of experience, Your Lordship.
The complaint alleges violation of the mandate of this court in order dated September 2025, whereby WP numbers 41243 of 2023 connected with WP 28782 of 2022 were disposed of. First off, the operative portion of the common order reads as under. Next correct. Learned counsel for the complainant submits that though the order had directed giving posting to the petitioner, appropriate posting to the petitioner by relaxing freshly prescribed qualifications, now the post that has been given is lower than the one to which his client is entitled to. First off, this aspect of the matter, contempt court cannot adjudicate, regard being had to the constraints enacted in the Contempt of Courts Act 1970, and also a few decisions of the apex court. First, next correct. In the above circumstances, the contempt proceedings are dropped, reserving liberty to the contemner to take up appropriate proceedings against the order whereby the writ has been complied with. First, all contentions in that connection are kept open. Yes, before the contest is put. Next.
Item 23.
My Lord, on 11/11/2025, this honorable court has issued notice, contempt notice to all the opposite parties.
23 Milord.
May I say? Opposite party number 4 only filed a compliance affidavit, not misleading one fact, which I have indicated in the reply affidavit. My Lord, your Lordship may kindly see the reply affidavit of mine.
What was the order?
May I be permitted to submit, Milord?
Yes.
This is in respect of PL in nature for construction of some village roads. One. So their mallards are specifically directed to the works department to do the job.
What is the order?
This is, my Lord, audited.
Consider the subject of
Yes. And it has been duly considered. Fact remains, my Lord, this is coming under, after the due survey for the work order, it is coming under the RD department, but it has not been added as a party. Works department has added as a party. However, after receiving the said copy, internal communication, though it belongs to one roof, my Lord, they have submitted to the RD department. They are in the process, but RD department has not been added as a party. So for the content, however, we have taken up this work.
Prague tools versus so and so. Departments of the government are limbs of the government, not agencies.
No, my Lord. It is under one roof, my Lord. No, I am.
Therefore, that contention does not avail to you. Tell something else.
But we are considering them, and in the process of work has begun, my Lord. Official process, because it is a departmental and sanction of money. So we are in process, my Lord. For that, I should.
When are you going to do that? Only as a concession. When are you going to do that? Within what time? I will give that time. I will consider your.
My Lords may fix the time.
What is the time?
My Lords may fix.
No. We will tell. Otherwise, I will issue arrest warrant.
My Lords, I had taken the instruction in the matter.
Yes. Within what period?
The representation of the petitioner was considered and he was communicated.
Considered means what?
Considered that it has been transferred to another department for consideration. That department is not a party, my Lord's word. And the result which was communicated to the petitioner, he refused to accept. And the same was compliance also.
Where is compliance?
My Lord, your Lordship, for a moment, see this kindly.
Sit down.
Yes.
Sit down.
Grateful.
My Lord, kindly.
Order is
my Lord,
to pass order on the representation.
My Lord.
Sending representation from this table to another table is no.
My Lords, kindly see the order.
Yeah.
Disposal order.
Yeah, I read that. Then only I am saying this.
My Lord.
Last for the internal page 10 of the order. In the above circumstances, this petition is allowed. The writ of mandamus is issued. It's all this. My lord, issue. Is issue. What kind of English? Issues to opposite parties to consider the subject representation dated 4 elements 2024 is copy or present within a period of 4 weeks. And in accordance, report of complaint should be filed with the Registrar General.
My lord,
Where is the
it
consideration?
was communicated also. My
Where is the consideration? Standing from one table to another is no consideration.
lord, he is not competent to.
That is when they do not say that plead without reading the judgment of the apex court.
My lords, kindly see the letter dated 18/6/2025, my lord.
Sure, 18/6/25.
My lord.
When we disposed of the petition?
1/8.
180. Therefore, 18/6 will not go back in the reverse gear.
No. My lords, I'm sorry. My lords, here.
Tell the registry to allocate 1 day of 20% for me because I have issued a response. Otherwise, they have to remain in prison. Yes.
We give some breathing time as it will.
My lords, it was in fact the work order
will give you time.
Will be issued by the concerned department. Now they are actively considering. It was allowed also, sanctioned also.
So next date you will do that.
My lords may grant 4 weeks time. But so far this particular allegation is that not correct.
Reluctantly, a period of 4 weeks is granted for reporting compliance. But at the request of learned AGA, Mr. Begura, and Mr. learned AGA, Mr. Hon'Ble, no further extension will be granted and punitive action may follow. If there should be the complaint should remain short. Item 24.
I may pardon my visit that item 22, because of traffic jam, I could not take up. Complied, my lord, that has been complied. I am preparing for it.
Complied.
It is my problem. Because I could not appear my for that. My appearance may be noted.
That matter can the RD department be included? It will be
included. See, that contention you should have taken when the order was being passed. You should have said, you should have told Mr. Judge, we are not bound. We cannot pass that any order. It is another department. That you should have pointed out. Having suffered order, you cannot say all that. Yes. Item 24. Raga tools. Raga tools versus swine.
No, my lords, here.
Anyway, you are given time now. Next.
My lord, item 24.
Yes.
Compliance is there. My lord, we have not filed compliance, but order has been passed on.
They
have not communicated.
They have not communicated.
Yes, it is communicated to the petitioner itself.
Do you have copy at least?
I have not extra copies, in fact.
You will copy you. I understand. Government is very poor. It cannot provide another Xerox copy to the judge.
Speaking order, your lordship directed, to which I had, we had passed an rescind order.
Non-submission of 11 documents.
Yes.
Complaint alleges violation of the order of this court dated 12/8/2025, whereby the writ petition was disposed of. Writ petition 22572 of 2025 was disposed. First, the operative portion of the order reads as next paragraph. Learned counsel appearing for the OP supplementary argues that the order in question has not been complied with and therefore contemner should be held up for contempt, offense of contempt. First, learned AGA per contra places on record the office order number 13287/VE, V for volleyball, E for employment, stroke 25 dated 10/12/2025. What have you written? No, full sentence. Learned AG. Whereby the the writ has been complied with. First one. Next paragraph. Learned counsel for the petitioner submits that there is no substantial compliance and therefore the cause remains. First, this court does not subscribe to that way. Next paragraph. In view of the above, the complaint is dropped in terms of compliance with liberty to the complainant to take up grievance elsewhere in accordance with law if he is aggrieved by the said order of compliance. In that connection, all contentions are kept open. Proceedings are dropped.
Only one submission, the copy may be used.
Yes.
You will now only
My lord, I will give it. I will give it. It is mine.
After disposal, they do not serve us the copy also.
No, I will give it.
If contempt is a matter between court and the contempt, your duty is over.
Only regarding serving of the copy.
Item 25.
My lord, the order.
25, my lord. The compliance affidavit was filed by the DEO Kalahandi. Lordship.
What was the order?
The order was.
Go to the operative portion.
My lord, I am coming to it.
There were circumstances
in the above circumstances, this petition is allowed, writ of certiorari issued
to issue appointment order.
My lord.
On compassionate note. Have you issued?
My lord, it is issued.
Sure.
Again, in the annexure A by 2, it is there in the complaint.
Produced it.
Yes. Let's kindly have a look at the compliance affidavit.
Yes, appointment order has been issued now. We'll record that submission.
Order copy has been already completed.
Obtained. Learned counsel for the complainant very fairly submits that the writ of this court issued by the order dated 18/8/2025 entered in WPC number 12301 of 2024 has been complied with by issuing the comparative appointment order and therefore proceedings be dropped. First one. Learned AGA Mr. G also has filed a compliance affidavit producing a copy of the order of appointment and seeks dropping of the proceeding. First one. In view of the above, nothing remains to be considered in the complaint and accordingly the same is disposed of. Next.
Item 26.
26 part financial benefits have been given, my lords, in terms of this honorable court's order, my lords. Lordship, kindly say page 16 of the lordship, sir. This is the para 4.3.
4.6 kindly order.
Yes, kindly recollect, my lords, that matter.
Compliance was filed on 19/1/2026.
19/1. The copy may be solved.
Yes, I am solving.
Give copy.
It is there. It is there. Let him check it out.
Directed to pay 28,000.
28,000. That has been paid.
And 250 rupees cost.
First part. My lord, the compliance is like this, my lord.
Yes, compliance. What was the period given for compliance?
Your lordship directed litigation cost of 28,000. 1%.
1,000.
My lord.
1% extra levy.
My lord. Accordingly, the department acting strictly within the four corners of the said judicial pronouncement and without conferring any additional or unintended benefit upon the petitioner, sanctioned remuneration at the rate of 25 rupees per class, together with at the rate of 1% and litigation cost of 28,000, culminating in a total sanctioned amount of 7,26,011 rupees. That is 26,011 rupees.
You have paid that?
Yes.
Yes, madam.
If your lordship, no, if your lord, I'm sorry. I'm sorry. I'm sorry.
Yes.
Oh.
Have you paid 7,26,011 in time? And if there is delay, rupees 250 per day from the pocket of the officer. Pass over.
My lord, kindly pass over it.
Pass over. Pass over. Simple.
My lord.
If you show that, it's over.
Yes.
Arrested detention. Yes.
Item 27. Yes, 27. Kindly see the last order, my lord. Last order dated 12/12/2025.
In this case, 2 weeks time may be given so that.
Lord, kindly see the last order. Lord AGA submits that compliance shall be reported by next date of hearing. Call this next week. This was by 12/12. Now, meantime, more than 1 month. And this is relating to grant of one notional increment.
Notional increment given by.
And covered by Supreme Court judgment.
Complaint alleges violation of the order dated 12/12, non-compliance of the order dated
30th July.
No.
Main order, repetition order, 30th July.
37/2025, wherein the operative portion reads as a last but one paragraph. First one. The contemners were granted.
Sole contemner.
The sole contemner was granted a period of, which is that order, another order.
Another order, my lord, that is content petition order, order number 1.
2020, granted, void order date, void order date is 12/12/2025. Which reads as under. First of all, till date, there is no compliance in terms of undertaking. First of all, thus there is non-compliance of the order and there is breach of undertaking. First of all, therefore, it is a case of aggravated contempt. Next paragraph. In the above circumstances, issue arrest warrant against the
sole contemner, my lord.
Contemner to produce him before this court on 22 January 2026.
My lord, it is one instruction I had received in this case. That is, on perusal, I'm placing that instruction, my lord. On perusal of the aforesaid order dated 37/2025, passed in WPC number 2110625, it would be revealed that the writ petition has been disposed of with a direction to dispose of the representation filed by the petitioner in reference to the judgments, finance department, so and so. As such, representation submitted by the petitioner under Annexure 2 series under due examination in the light of references made therein. And this will take few more time, at least 2 weeks for completion of process.
Arrest warrant against the contemner to produce it before this court on 22 January 2026 or 26 first. However, in the meanwhile, if the compliance is reported, there shall be no coercive action in terms of this order against the contemner. Or
both the matter same, both the
same order.
Same order in both the cases.
Item 28.
This is Lordship's kind permission. Yeah, and then Mr. Patti has come.
Yes, brother. Do you want to show concession? If you show concession, I will tell him. Otherwise, I will not interfere once I impose the cost.
Payment has been immediately made of first under Lordship
That
direct.
is not the question.
Due to mileage order,
The court.
due to mileage order, the petitioner is struggling since 95 got that benefit.
Question is simple. If you want to show mercy, you tell it, I will relax that amount.
Yes, my relax.
Right? The application seeks waiving of the cost of ₹50,000 levied by this court wide order dated points, whereby writ petition was WPC number so and so was disposed. First one, learned counsel appearing for the office submits that the substantive part of the order has been already complied with, and therefore the levy of cost will recalled. First one. With this proposal, learned counsel appearing for the petitioner is agreeable in all fairness. First, it is appreciable also. Next paragraph. In the above circumstances, the cost levy part of the order stands recalled.
It's order dated 20th of August 2025.
20 August 2025. WPC number?
WPC.
Same. Yes, grateful.
Item 28.
No, this is violation of interim order. In the last order, that is 11/12/25, the Lordship has just categorically stated they are warned that non-implementation of the interim order may result into arrest and detention. In spite of this order, my lord, they have not complied.
Where is that
Time was spread for my lord.
where is the threat part of the order?
This is the second paragraph of the order. 11/12/25. 11/12/25 order.
Go to 11.
That is second paragraph.
Yes, brother, why not?
My lord, they have, because it's a intra-departmental communication, and the person who is mad party.
The complaint alleges violation of
They are asking
the
for
order
time,
dated, which is that order? 19/9/2025, whereby complainant WPC 25607 of 2025 was disposed of. First off, the contempt case came before this court on 11/12/2025, and this court had threatened the contemner of arrest and detention should the writ remain uncomplied. First off, even this does not threaten, this does not deter the OPs who are very, very thick-skinned. First off, next paragraph. In the above circumstance, issue arrest warrant against
all the
OPs and produce them before this court on 22 January 2026. First time. However, if in the meanwhile the order is complied with, there shall be no coercive action against the said OPs in terms of this order. It will happen. Or at least we will see them when they are brought before the court by police, like accused. Yes.
Item 29.
29 also sometime maybe.
Yes.
Some time I'm trying for.
What is the order? When the order was made, why not complete?
It's a representation disposed of.
Where is it?
If your lordship will give me 2 to 3 days time, I'll file compliance.
The
may call this matter on.
Contempt alleges non-compliance of the order dated 9/9/2025, whereby complainants WPC 23967 of 2025 was disposed of. First off, till date there is no compliance. There is no compliance with the said order, and there are no symptoms of compliance as well, except that learned AGA Mr. G seeks some time. First off, this court is not impressed. Next paragraph. In the above circumstances, issue arrest warrant against who is the OP? Which OP?
Opposite part number 3.
OP number 3. And to produce him before this night on 22 January 2026. For answering, for offering explanation as to why compliance is not done. First time. However, same class. Do you know that? Yes. It will happen. Yes. Item 30.
May it please. My lord, notice went on 15/12/25, my lord. Emergent notice. No SOCAs yet been filed by all the contemners. Order was passed on 17/9/25.
Notice is served on the side.
Yes, my lord.
Served them.
Yes, my lord.
Right.
Recusite also filed, my lord.
No non-compliance. Who appears for the OPs?
No, it's university. They have.
It is also there.
University
is there.
Whether Vice Chancellor is there?
Yes.
My lord, Vice Chancellor register.
Yes.
2, 3, 4.
Yes. This complaint is non-compliance of the order, common order dated 17/9/2025, entered in WPC numbers. Sorry, there are 2 numbers. The operative portion of the order reads as under. Next paragraph. The OPs have not complied with the said order despite notice by this court. Wide order dated, notice was issued on when?
15/12/25.
15/12/2025. There is nobody representing them. Call out those names. Call out the names. Call out names of the registrar, vice chancellor, everybody.
Service written is not there, it is written. The office note.
Office, whether service is complied with. Service is done on them.
Through police, it was.
It is done?
Yes, my lord. Through police, it was the direction.
We're asking you, do you know that the police has served you?
My lord, about police, we don't have, but
Next.
we have filed the SR.
Yeah.
But sir, the SR has not been received.
Sorry, not received, not recall that. Issue. This order, this court wide order dated, which is order dated issue notice?
15/12/25.
15/12/2025 had directed the service of police notice on the votes. First off, there is no report of service by the police. First off, therefore, the with Inspector of his police station,
Saidnagar police station.
Inspector of police, police station, Patak
Bhubaneswar
is directed to be personally present before the court on 22/1/2026 for not complying with the order of this court. Semicolon, failing which he shall be brought before the court by police force. Yes.
Grateful. All three matters, two matters.
Same order. Yes. Next. Item 31.
31, my lord, this is an interim order. While staying the operation of a particular order, my lord was pleased to direct that original order 26/8/2025 was to be complied with in its original position.
Is it complied?
No. Today my friend has filed an affidavit, but they have stated one paragraph only, thereafter they will submit.
No. What they say? I will comply with the order. What was the order?
Yes,
read the order. Directed to extend the benefit of office order dated so and so,
my lord.
Before, as before, during the pendency of the petition and so and so.
Yes, ma'am. I'm just filing, my lord, I'm filing a.
You are filing the compliance report. Yes, ma'am. Have you extended that?
Yes, ma'am. So your lordship may see Annexure 2. The last page, Annexure 2, page 8.
Annexure 2.
Annexure 2. It should be Annexure B/2, my lord. I'm sorry.
No problem. 2. You copy to him. Have you given?
Read Annexure 2. My lord. I have read, my lord.
He has to. It is his.
Oh, he is. Yes.
In pursuance of the order issued by the Hon'Ble High Court of Orissa dated 12/5/25, passed in WPC number this, order dated this in WPC this, and order dated this, passed in contempt, filed by Dr. Sarath Kumar Rao, Department of Education, Ravenshaw University, Office Order number 3407 dated 28/25.
It has been withdrawn, rescinded.
That was, my lord, have stayed that.
And that is
that order itself, 8/10/25 order, my lord have stayed.
Restored.
No, that is restored. See that?
No, I have read it. Let him complete. If my lord permit, no. What happened, my lord? 26/8/25, the order grant me the benefit pursuant to an earlier order of the petition. Without any reason, only one line order 3/10/25, that order was withdrawn. Original 26/8 order was withdrawn. I came before my lord. My lord, while granting stay of that 3/10/25 order, directed that you should comply to 26/8/25 order. 26/8/25 order that I should get the pay protection. I should, my service, past service in the Central University has to be counted, integrated to the university service.
Yeah.
That was the direction. And by virtue of my lord's interim order, 10/10/25 order, my lord have directed that order should be complied with. Till date, I have not, that order 26/8/25 has not been complied. What they say in para 7, kindly see in the SOCOS itself. They have written to the government and it is their contemplating. Probably that is the order.
No.
Let me read out that. Let me complete, then you will say. Para 7.
Para
of the
7 of
SOCOS reply today, my friend has filed.
Yes.
That, shall I read, my lord? Page 5. Today's affidavit, my friend has filed.
You have not numbered the pagination, he has not done.
No, he has done it. Today, just
This one he has done, in mine they have not done.
I'm so sorry.
Anyway.
I'm so sorry.
Anyway, they are casual and don't worry about it.
Paracel.
I am accustomed to that casualty. Some things
That it is-
will happen. Yes.
that it is humbly submitted that the order passed by this Honorable Court on 10/10/25 in WPC 28693 of 25, IN number 1799 of 25, has been duly complied with by Ravenshaw University. Full stop. Ravenshaw University is taking all possible steps to provide all benefits under office order dated.
Yes, when are you going to provide?
That is not.
It has been approved by the university. It's pending at the level of the
It makes no sense. Your argument makes no sense. It's a court order.
I will send this API message to my friend here and just pass the note. It's a confidential note sheet here.
What is confidential? Is there any CORA in that?
No, it's a service record. Basically, because he has written to the higher education department to sanction the funds, and they have because the funds will come from the state government, it doesn't come from the university.
That is not the order. Order is not contingent.
Well, it's
your lordship's order is that the impugned order is stayed with the direction to extend the benefit of the order dated 26th August. We have done it on paper. The benefit will be extended by the end of the month. Your lordships may grant us that much. By the end of the month, all calculations will be made and all benefits will be sanctioned.
But that is not your affidavit. They have misled the court.
Well, we have just stated that we have taken steps. We have already.
That is very evasive for the. It is a university.
Yes.
Evasive for the vice chancellor and the registrar, to say the least.
Because the order has been rescinded.
Are you complying with the order, or I should issue arrest warrant against the vice chancellor and the registrar?
We'll comply with the order.
Come with the compliance at 2:30. Yes.
We have taken steps for compliance. It will take some time because higher education department has to sanction the funds. We have already rescinded the order which was withdrawn in state by law.
That makes no sense. You are only repeating what he has said.
And given full effect to the original order.
That give effect, that court are passing some order on the paper is no order. The fruits should reach. Fruits of the order should reach the hands of the litigant.
Grant me 1 week time. We will do it.
The contempt, this complaint, this non-compliance of Intel model.
Yes, ma'am.
Dated 10/10/2025, entered in pending WPC number 28693 of 2025. First off, the operative portion of the order reads as under. Last paragraph. Next paragraph. The contemners have filed an affidavit. Where is that? Give that. In the open court with leave, stating that the order in question has been complied with. First off, in para 5, para 6,
para 7, page 5.
Para 7, page 7. No, at para 6, yes, the affidavit reads as under. First off, this is an evasive statement. First one, compliance of the order means putting the financial, putting the money in the hands of the complainant as directed by the order in question. First one, that has not happened, although some paperwork is done. First off, therefore, court is not satisfied with this evasive contention. First off, next paragraph. This court wanted to issue arrest warrant against who are they?
The registrar and vice chancellor.
The registrar and vice chancellor of the university for not complying with the order and also for taking up evasive contention in the compliance affidavit. First, however, reluctantly, this court does not do that now, since the counsel advocates appearing for the contemner fairly submit that the observations of this court would be kept in view, and the order in question shall be in with exceptions complied with within
30th January. 30th January.
You said 1 week. Therefore, I was giving this time.
One week.
Within 1 week. 1 week. First time. Now, in the above circumstances, call this matter on 22/1/2026 for reporting compliance, failing which the contemners run the risk of arrest and detention.
Your Lordship is more generous.
No, I am not. In fact, matters I am not generous. Order of the court should be complied with.
Your Lordship is absolutely right.
There is one instance I will tell you. In Ramayana, last chapter, when Rama and Lakshmana jumped into Sarayu river and committed suicide, which many will not be knowing, there was an important meeting held in the court of Rama, in the royal court. Rama instructed Lakshmana not to allow anybody to enter the hall. And somehow, I believe Vasishtha Maharshi came and said, immediately I want to see Raja Rama. Lord Rama asked, how is that Lakshmana permitted you to gain entry? Then Vasishtha Maharshi said everything. In fact, Rama wanted to take stringent action against Lakshmana for violating the Rajagya and went to see Lakshmana. Then he was told that Lakshmana has jumped into the river. Rama also followed and jumped into the river. This is the true rule of law, Indian rule of law. We did not come to learn rule of law from Daisy. We do not learn it from Daisy at all, Devi Daisy at all. We learned from Ramayana, Mahabharata. This is how. Second one I tell you. There was Rama Shastri Prabhune, a village magistrate, who had directed arrest and detention of Peshwa for not releasing salary to the soldiers. And police did not comply with the order because Peshwa was the Raja. And all police were servants of Raja. Then that village magistrate left that village, saying, where Raja does not comply with the orders of the court, in that kingdom, the sunset should not be seen. That is our rule of law. Our order may be wrong, but you have remedy to against them. But as long as the order remains, compliance is a must. Therefore, if you falsely say that I am generous, I should truthfully say I am not.
It's absolutely not.
Next. Wait. You tell your Vice Chancellor, otherwise their photographs may appear. Yes. Item 32.
One of the order judgment dated 4/9/25 has not been completed and notice is issued on 16/12.
16/12.
Madam, not kindly see order. Still did not complete.
My lords, the order was passed on 4/9/2025.
Correct.
Giving 3 months time.
Yes. 4/9, 3 months will be when?
My lord,
means 4/12.
He has filed the application on 1/12 before that date. Anyhow, I'll.
No, that makes sense. Now that period is over.
Oh, your lordship may grant some time.
No question of that. We grant time for police to produce. Yes, right now.
My lords.
The complaint alleges non-compliance of the order dated 4/9/2025, whereby complainants WPC number 18172 of 2024. First, this court wide order dated, where is that notice also?
16/12.
April 2025 had said as under. Yes. Next paragraph. Even the text of the above order does not deter the contemners, they being as thick-skinned as buffaloes. First of all, this is not a good thing to happen. Next paragraph. In the above circumstances, issue arrest warrant against the contemners and to produce them before this court on 21 January. Yes. However, if in the meanwhile the compliance report is filed, the this direction will be kept in abeyance.
No, my lord, so one thing, I have no instruction whether they have filed appeal. That may be indicated, my lord.
If there is a, then you should show that to the court or to the police. Yes, next. Item 33. Otherwise, Mr. Beura.
My lord, my lord, so why I am pointing out, if they have filed writ appeal, then.
Yes, next.
Next one, your lordship kindly see last order, last bar of the order dated 16/12/2025. Last paragraph third, delay is viewed, but till today.
In which matter? Next matter?
Next, 33.
33?
33, madam.
Okay. Complaint alleges violation of the order dated 8/9/2025, whereby he is a WPC number 2433 of 2025 was disposed of first up. The operative portion of the order reads as a next paragraph. Despite the threat contained in the last part of the order, the order in question, there is no compliance. First up. The container appears to be buffalo skin. First time, to say the least. First, next one, in the circumstances, issue arrest warrant and produce the containers before this court on 21 January 2021, 22. 22, earlier and also 20. Just going to that. Yes, sir. Yes, 20. Yeah, first part. However, if the order is complied with in the meanwhile, no coercive action shall be taken against the containers in terms of this order.
Item 34.
Now that will happen.
34 also same, but there are three opposite party, three number of three opposite parties.
There are three OPs. Three containers. There is one method, three containers. Same order.
Same order, same date.
My lords, only item 32, I require little more time, my lord. 32.
These two.
My lord.
No, we have already ordered.
My lord, because the regular.
26. Oh, sorry. 26, my lord. It was passed over.
25. Item 35.
No, 26 was passed over. The lordship wanted.
26 was passed over.
Yes. Lordship wanted me
to
verify whether payment has been made or not. It is, payment has been made.
Let's say,
when did you get
so-called affidavit they have served, my lord, senior is serving in court, my lords. The only claim, my lords, kindly taken up on next today. I will file a reply, my lords, because this kindly
like that. Contempt is a matter between court and the contempt. You have no say. You have already brought to the notice of this court what is what. 7,26,011 is paid.
7, yes, my lord.
But net amount is 6,93,460. Why?
My lord, that part, my lord.
No, why? Less than 7 lakh.
No, it is 6 lakhs.
93,000. 6,93,460.
Yes, but it was 7 lakhs. It was calculated.
Yes. Any tax or other things are deducted. Contempt alleges, this complaint alleges non-compliance of the order dated 8/9/2025, whereby complainant's WPC number 19969 of 2023 was disposed of. First one. The learned AGA Mr. G appealing for the contempt. How many contemners? 4 contemners. Submits that a sum of rupees 7,26,011 has been handed to the petitioner after deducting the deductibles in accordance with law. First off, he draws attention of the court to the principal's endorsement dated 11/2/2025 to that effect, issued to the Treasury, District Treasury Officer.
Yes.
District Treasury.
Mayurvanch District Treasury.
First off. Next paragraph. in view of the substantial compliance of the order, the contempt proceedings are liable to be dropped, and accordingly they are. First off, if there is any other grievance, it is open to the complainant to work out the remedy for the same in accordance with law. First off, in that connection, all contentions are kept open.
That's good.
Next. Item 35. Yes. Yes, sir.
May please, Your Lordship. Here the
questions you had canvassed.
Yes. Here the facts are like
one is, even if what you say is, even if adoption is not proved,
yes,
he becomes class 1 heir.
Because the brother's son, no other heir is there.
Not class
that will not go.
Brother's son is what
will be displayed by a sheet.
Due to intersection.
Because he is the only male heir. But being brother's son, own brother's son.
That the other day also put whether in the succession rule applicable or not. That is also automatically.
Succession Act will not apply. Not apply. That is the.
The other question is that regarding the sale, because the plaintiff is the.
Yes.
If Hindu Succession Act is not applicable,
yes,
then what is the law applicable to your claims?
Custom. As I have examined, first comes custom. If custom is pleaded or custom is there, then custom will govern.
Where is the
inheritance and succession both?
Where is the pleading?
And in absence of custom, justice, equity, and good conscience.
No.
Rule of justice.
No.
Yes, that is. I have got a decision.
Yes.
Of the Apex Court.
In succession.
Yes.
In succession,
yes,
also justice.
Yes.
Is it?
I have brought a decision. Your Lordship may see. This is the latest decision of the Apex Court.
Is it a matter relating to succession?
Yes. Whether female heir can succeed, being tribal, being belonging to communal tribe, scheduled tribe.
Reference to the court.
Okay, no, but the line they reach. That's the only reading. 17/7/25 mission date of judgment 17 July 25.
25. No, that was mainly a case of Article 14. Because the share was denied to Srimati Dhaya, the daughter.
Female heir. Yes.
That violates Article 14.
Belonging to scheduled tribe.
Correct.
Yes.
That violates Article 14.
That is the decision, and all the decisions have been taken note of in that decision. Your Lordship, it may be of some help to us.
That's fine.
Yes.
Let us see.
I have got the decision.
Make notes on this.
And here.
Anyway, I will not hear it because I have to read it.
Yes. Yes.
May I get the reference?
Yes. I will give you the reference. I will give you the reference.
I'll give one copy from our Xerox. Give Xerox of the copy to Mr. Mishra.
Yes.
We'll call this on the date of hearing.
Yes, Lordship, you can get.
For this matter, on the date when this judge sits single, as requested at the bar, since some rulings are cited, rulings of the Apex Court, some ruling of the Apex Court is cited, which needs a thorough study. First off, all right, we'll see. I have brought a small gift to the members of the bar. I am sending it to you. They are the bands for young lawyers brought from Delhi. They are good bands. Kindly distribute those gifts to the members.
Yes, yes,
members of the bar.
it will
We
be-
have put in about 6-7 years of service.
On behalf of the bar, Professor, thanks to your lordship and also we're obliged to the lordship.
500 or so.
So, but your lordship will send or I'll send somebody to.
Yes, send somebody.
I'll send somebody to lordship.
So I am submitting a memo for the next city.
Next sitting, take that.
Sir, one passover is still there.
Passover is there. Which is that matter?
Item 13.
1-3.
We're really obliged to your lordship.
My, all people love me so much. I owe it.
Item 13.
1-3.
Yes.
What is the order, brother?
The modification of order.
None appears for the parties. All when this matter, judge sits in.
I have just a request. Thank you.
What is that
thank
matter?
you. Just, I have a writ petition. Here I am the petitioner. And order dated on 17 December 2025. It was called this matter on 8 January 2026.
8 January. 8 January, I did not sit single. Actually, on the next date of
So
it, when I sit single, post that.
Kindly mention.
Yes,
list
give that
this matter.
ma'am. When this judge sits single. Post it on 20.
Item 13 was also passed over. Item 13.
13, none, there is nobody is appearing. No? Therefore, we call it that.
notice not returned from respondent 4. Are we permitted to take fresh notice?
Yes, take fresh notice file. Fresh notice.
Item 11.
In 1-3. Yes, Mr. DSG.
Well, at item 11, there is a matter is pending. Seek from instruction from the department. We are the petitioner here.
Appellant.
But appellant. And issue that the similar issue also pending with the Allahabad High Court, some ground has been taken. Then Lakshmi give correct time.
No, Allahabad High Court, if we decide this issue, Allahabad High Court may follow our.
Yes, sir. That I'm just saying that only give me some time based on that.
2 weeks. At the request of Laliti, final.
That time
the request for adjournment shall not be entertained. Yes.
Land action appeal law
To continue.
Implement to continue.
42 by 2017. Twice it is listed has been 25/6/2025. It was order to listed, but it is not listed.
Not listed.
Pardon to make a mention, Your Lordship.
Yes.
Your Lordship, this is an after notice matter. There are 2 writ appeals and 1 contempt matter arising out of a common judgment, Lordship, which were disposed of. In this matter, what happened, my lords? My claim for regularization was rejected by the Honorable Single Judge.
You want?
I wanted to be listed for Monday, my lords, because now the appellants were suffering.
Which matter?
Both the matters, because it is identical cause of issues are related. Not in the list, my lords.
In the list, you want motion? No memo, na? Okay, file memo.
My lord, item 9 kindly taken over next week, my lord.
Serial number?
Item 9, my lord.
Wait, 10 up to 10 are not mentioned. Right? You people do not appear to go to other high courts at all.
My senior is not well, my lord.
Wait, when it reaches you, because getting the matter posted is a Herculean task in this court. Even when we order, they do not post. Kindly wait. Let us ask the other side also. We do not know.
2017 matter, my lord, against the order.
2 weeks.
I don't mention, my lord. Item 15. I am for the petitioner and opposite party counsel for opposite party is also present.
Is also present?
Yes, present. All 2 are present. Here, what happened, my lord? Pleading already.
No, what do you want?
I want adjournment to say 2nd February or 9th February.
Objection, that is the matter related to CPO to GPO already.
We are asking.
Objection.
Do you object or do you agree?
I'm not, let it come on 27.
27.
Well, here, what happened? Counsel from Ranchi specially engaged to argue the matter, my lord.
He had already that argument.
He had already filed the Bhinama.
Which date you want?
2nd February or 9th February?
February.
2nd February or 9th February?
9th of February.
9th February.
9th of February. At the request of learned counsel. Counsel for
petitioner. I am for the petitioner.
Petition.
Because one matter already
chosen from the calendar with the learned counsel.
On one matter already been dismissed by the court bench.
I
got to 100 I am 109. I am person.
In this case,
my lord.
Do you oppose or
no?
Next.
Item 1, may I please, my lords? In this case, my lords, the appellant is the small shop room owner, my lords. Shop room.
Item number 1. I am for copy number 2. I am filed a caveat matter. Advance copy has not been served on us.
Lords, I will solve a copy, my lords. Let it come in the benefits.
Moreover, my lord, there is one more matter with a similar issue. That
call this matter along with which is that? 1958 of 2025.
1958 of 2025.
1958 of
2025.
25. First one. Come on. After 2 weeks. Yes.
Item 2.
Item 2 is the my lord government appeal. Wherein this judgment of this honorable court dated 23/2024 is under challenge. The crux of the point here. Regarding grant of pensionary benefit to the divorcee daughter who has passed this decree after the death of the principal.
Has
after the death of the petitioner. What is the father of the petitioner, my lord? The present petitioner.
The death of the deceased divorcee daughter by Clement Paul.
Yes.
And she got the divorce only after the death.
After the death.
In other words, as on the date of demise,
yes,
she was not a dependent.
Exactly. That is the crux of the point, my lord.
There are two High Court judgments. One is of Allahabad High Court, another is of Kerala High Court. They are conflicting judgments. Therefore, we will.
But the rule says 82. Yes.
Will issue notice. The short point urged by the appellant is as to the entitlement of a daughter.
My lord, there is a limitation.
Was whose marriage was dissolved by a decree of dissolution post the demise of the employee dying in harness. First, matter requires deeper consideration. Issue emergent notice.
So far the limitation is concerned,
that to it, notice both on petition and yes.
Item 3.
What item?
Item 3.
Lord, it's an intra-court appeal where the direction was given to regularize the services of the petitioner by passing appropriate orders. My lord.
How many years they have put in service?
He was of this recruitment was made in the year, the management has made in the year 2014. It is a Group C, Group D post. It is our categorical averment that his engagement was 27/11/2015. But by then, my lord, Group C, Group D posts were abolished by way of a rule, 2013 contractual rule. All the
abolished on which date?
Abolished in the year 2013. 13 rule.
But appointment is subsequent.
Subsequently thereafter. And the posts are not there, my lord.
But for 11 years they continue.
My lord.
10 years. About less than 10 years.
My lord. That's why he is claiming for regularization.
What do you say about Uma Devi?
In the Annex 3 to the writ petition, it is a vacant post, my lord. It is not abolished.
My lord, the concept is
appointed against
the Uma Devi says at least 10 years existing vacancy in a sanctioned post.
Yes, my lord.
Where is the 10 years period?
But that the brief I have not with me.
Issue.
Notice also.
Notice. Both on you have a delay also.
Delay is there, 208 days delay.
Why you can have your separate limitation act of your state. Issue emergent notice. Learned Counsel Shri signs so accepts notice for all OPs.
All OPs, yes.
How many OPs? How many respondents?
My lord, respondent, only 3 respondents.
All the private parties?
Private parties, one is his. He is to
notice for respondent number 1. Urgent notice to the rest.
2 and 3 is the OUAT.
All right. Next.
Item 4.
Yeah.
Item 4.
It is a state appeal.
What's the point for consideration?
On behalf of OP number 1, I have received.
Challenging the judgment of the Hon'Ble single judge.
What's the point? What's the point involved in appeal?
My lord, here, my lord, the person has entered into the data entry operator post by way of a hand receipt in the year 1995.
95?
Yes, ma'am.
It is about 30 years.
30 years. Subsequently, came into the cadre.
We decided one data entry operator's case. Which is that?
That is in Supreme Court, that is Patita Pavan Datta Das, which has referred to the Hon'Ble Apex Court. The same has been completed in the meantime, 2 weeks back before Milord. No. Regular. But here is a case, this is covered by Sanatan Sahu Milord.
Against you?
Yes, ma'am. But we have to check it.
Sanatan Sahu is by DB.
Sanatan Sahu is by the single Milord. This case is Sanatan Sahu.
But already 30 years. What's that?
They are claiming is to enter into the cadre Milord So far the senior data entry operator is concerned.
No, what is the...
Keeping in view the initial date of joining, that is in 95. At that point of time, he was a hand receipt. And their service all the covered under the particular rules enacted by the state. Odisha Secretariat Data Entry Operators Methods Recruitment Rule of 2008.
No, the reasoning appears to be logical. The reason given by the learned single judge at paragraph
21
appears to be very logical. At least that fits into the contours of contemporary service jurisprudence. What is the lacuna? You have to make out now just showing that order is wrong is not sufficient. Order is wrong and it is otherwise also unsustainable. Two things you have to satisfy. Order may be wrong. Every order will contain one or the other infirmity. That is no ground for interference.
There is a
24 Supreme Court.
There is a limitation, my lord.
The top part limitation is also there.
113. 113.
113 days. We'll condone delay, but we'll dismiss the appeal. Oh, you appear for solo appeal.
Yes, ma'am. Solo.
This intra-court appeal seeks to call in question a learned single judges dated
10/6/2025.
10/6/2025, whereby OP's WPC number 29172 of 2020 having been favored, the order as to the fixation of inter se seniority of the employee in the cadre has been settled. First one. Appeal is filed after booking a delay of 13 days, and an application is moved seeking its condonation. First off, the said application is supported by affidavit, and a plausible explanation is offered for the delay proved. First off, learned counsel on request appearing for the OP on fairness submits that application be allowed and delay be condoned. First off, we appreciate this virtuous stand. First off, even otherwise, no prejudice should be caused to the OP by condoning the delay in as much as matter would be heard on merits. First off, in view of that, application is allowed and delay is condoned. Next paragraph. Learned counsel for the learned AG appearing for the appellant government and officials.
Yes, ma'am.
For the appellant government and the officials. Government officials. Submits that the fixation of seniority as between the employee in the cadre is a matter of prerogative of the department, which exercise has to be accomplished in the light of extant guidelines promulgated by the government, and therefore the impugned order which ignores such guidelines is liable to be settled. First, learned counsel representing the OP resists the appeal, making submission in justification of the impugned order at the regions on which it has been constructed. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, this court declines indulgence in the matter in as much as the learned single judge at para 20 of the judgment has given elaborate reasoning as to why the extant circulars and memos of the government cannot be acted upon. First off, he has also cited the decision of the apex court. First off, the said paragraph reads as under. Next paragraph. Learned counsel appearing for the OP is more than justified in contending that in an intra-court appeal there are inherent limitations, and therefore just showing some one or the other infirmity in the impugned order is insufficient, in as much as what is required is that demonstrably wrong apparent from the face of the record. First off, such a demonstration lacking, he contends, appeal is liable to be rejected. We agree with this view. Next paragraph. In the above circumstances, appeal being not sans merits is liable to be rejected, and accordingly it is, courts having been made easy. First off, the appellants are directed to implement the order of the learned single judge within how many days? Any positive direction is given with a direction to so and so to align in the lines of the provisional gradation list within a period of 8 weeks. Within a period of 8 weeks, refixation of gradation list.
It will take some more time.
3 months. First off, delay, if could, shall be viewed very seriously in the next level of the legal battle. Yes.
Item 5.
May please, madam. Let's secure lordship's mercy.
Mercy.
Protection.
We don't have mercy jurisdiction. It's only
Merciful jurisdiction.
Yes.
Because the Honorable Single Judge, by his order, has rendered the petitioners homeless, your lordship. My lord, the conspectus of the case is, in this state, there is a tradition that jamindars used to have various other caste people to serve them. So they used to give them piece of land to stay and piece of land to cultivate, so that in lieu of providing service to the jamindars. Now, what they do after that, because there are various caste people and all that, they donate that land to Lord Jagannath, so that those people that they have given shelter are never removed. They remain under the protection of Lord Jagannath. There are a lot of properties like this in this state, donated by such jamindars, having occupants, donated to Lord Jagannath. Now, this constitutes a kind of property which is called the Amruta Mohi property of Lord Jagannath.
Amruta Mohi.
Amruta Mohi property. That's the name.
Mohini. Amruta Mohini property
of Lord Jagannath. Now, though these lands are all donated to Lord Jagannath, because of the fact that it is occupied, most of the land is under occupation, Lord Jagannath doesn't get any revenue out of it. Therefore, a conscious decision, a policy decision was taken to settle these lands in the name of those who are residing on them, if they come up with evidence that they are residing and occupying the land. Well, such is the case with these petitioners.
Which policy decision means, is it a statutory policy or executive policy?
It is a policy under the Act. There is a Jagannath Temple Act.
Read the provisions.
My lord, the policy is...
That policy is relatable to which section of the Act?
It is made under the Jagannath Temple Act. No section is mentioned. The policy.
Tell us.
I'll read the policy, Your Lordship.
Yeah. Does it say under which provision of the Act it is promulgated? Policy is promulgated. Because similar matter,
my lord,
I have already decided.
My lord.
The land gifted to the deity
my lord,
is the deity holds it in trust.
My lord.
And also has full ownership because of 1921 judgment of the Pre-Council. Therefore, unless there is a statutory policy, the diversion of land cannot happen.
No, correct. Your Lordship is correct. Here, this Amrutamanai property is meant for maintenance of Lord Jagannath. For maintenance, there has to be some revenue generated. Because these land were under occupation and no revenue was forthcoming, therefore a decision was taken and it was approved by the government. This policy was approved by the government, so authorizing that, making a very schematic thing that how this land will be settled under what, in what scheme. And Your Lordship, I had also submitted a booklet of information that following this policy, over 3,000 acres of land have been settled in. That's not a, but here Your Lordship, at page number 66.
66 is policy.
My lord. It starts from 64, relevant page is 66.
No, how policy reads in the name of government? Or some chapras in the government?
No. It was
how policy is structured linguistically?
Yes, my lord. The policy, may I read, my lord?
No. Who has promulgated this policy?
The trust, Jagannath Temple Trust has promulgated this policy. And has been.
Whether trust has such a power under the act?
Yes, my lord.
Show them. Which provision of the act empowers the board of trustees of the temple to alienate the properties on the ground which now you stated?
My lord.
It is a temple property.
My lord. It's a Jagannath
deity holds the property.
My lord.
Protected under article, which article? 25.
25.
Yes. Judgment Lakshmitra Tirtha Swami R versus
My lord.
Commissioner Hindu Religious Endowment.
My lord.
54 Supreme Court. Will you come with more preparation?
Oh, my lord. It's the only thing that no
performance is bad. Can't after 2 weeks.
My lord, only the coercive action may kindly be
nothing like that. We are not absolutely not. 1954 Supreme Court.
My lord.
The Constitution bench says a deity itself is a denomination. A denomination is entitled to hold the property.
My lord.
And it is a fundamental right.
My lord.
Therefore, in the light of that, you have to come. You just read that judgment and come.
Well, I'll come. Only thing is that these people have been residing since their grandfather's time.
That makes no sense.
My lord, they will be rendered homeless.
Deity is an eternal minor.
My lord.
It is the duty of the government and the courts to protect the property of the minors.
My lord, this property was meant for Jagannath Lord's maintenance. Because
no, we do not.
My lord, kindly.
Those for which you are acquiring the land, as is said,
right to land,
as any essential for the state department.
My lord, they have been residing in that land. There have been enough documents. My lord, just because the policy says and land that anybody who proves possession over a period of time will be set. That will be market price. This will not be settled without anything. It will be sold at a market.
It is covered by our judgment against you. And it is covered by the judgment of Apex AR 1954 AC 282. Lakshmindra Tirtha Swami R versus that famous Shirur Mutt case. There is a big literature by Basu and Sirwai on this judgment itself.
Well,
just look into it.
Here from the act, the policy is spread.
That you are not telling us.
That's what, because the policy was in Odia, that has been translated. That's what I was taking little time. That's what
you have to show.
My lord, Monday, let me commit
next week.
But till that time, at least till that time, they may not be evicted because the powerful people are there.
It is, we cannot sympathize the horse law.
No, my lord, it's not. Only because that.
Next.
Item 6. In item 6, my lord, I need some time because the letter dated 81, I want that.
In this case,
he wants time.
Because
I appeal.
Some part of the order has been implemented, my lord.
That's all right. Are you in KVA?
My lord, I have already appeared in.
Yeah, KVA is not. You have appeared after notice.
The notice has not been issued.
Notice has not been issued.
Admission is between the after time
exactly
for you. 2 weeks at the request of Planet AG. Yes.
Item 7. Item 7 matter relating to Hemant Chotra, my lord. That matter will be listed on 20th, your lordship director.
On this matter on 20th. Yes. At the request of Planet AG. Next. Item 8.
My lord, on behalf of Amni Kumar Mahanti, Annex 2 may be not pressed, my lord. Annex 2 maybe not pressed, my lord.
Annex 2 is not pressed. What is it mean? What is Annex 2?
Yes, what is meant by, what is our
Selector 2 is the order of the review petition.
But you don't press review. But this is an appeal, na?
This review was before the chief.
Yeah, it is meant to be TWA. TWA. Thank you. You want time? We'll give you time. You think and come back.
Possible, my lord.
Possible. Possible.
Item 9.
You kindly taken up next week, my lord.
Mine you want next week? 2014 matter.
No, my senior is not well, my lord.
He just mentioned before me just now.
Yeah.
I told her sympathetically that if you want time, inform me earlier. Should have informed me earlier. That's right. That should be maintained.
Nobody tells some advocates are waiting. We should tell them not to wait. This is
the age-old practice.
Exactly. Sensible practice.
We should maintain. If you want time, I have an objection. But next week, I have some.
Next week, all right.
Next week, I have some difficulties.
Can
I a date?
Yes.
February, can it be?
All right.
16th onwards.
16, 17, 2. 16, 2.
Yes.
Yes.
Right.
At the request of both the sides. Item 10. Yes.
May it please your lordships.
Yes.
Well, there are two writ petitions.
Sorry.
Two writ petitions before lordships. One is WPC number 17510 of 2015. Another is 16822 of 2015. Both have been tagged. One is filed by the workman. The other one has been filed by the management. I am working for the workmen. Now, briefly, the facts are just I'll submit a few sequence of facts.
Yes.
For better appreciation of my lords. Petitioner before lordship was working as a junior assistant in the office of Orissa Power Generation Corporation, the management.
Junior
assistant.
Have you joined employment on?
I have joined employment in 91 or 92, something like that.
So many dates you are telling. Yes. So amorphous it is. Anyway.
No, my lords. Here the question lies on a very, hinges on a very small question of law, which is, of course, can be demonstrated better by the management while placing their writ. Now, what happened, my lords? In 2005, two charge sheets were issued. That is on Annexer 2 and 3 of the other writ petitions. I am referring to the writ petition filed by the management.
What were the charges?
Charges were, so we'll see that indiscipline something, and I'll place those charges, my lords.
That's it.
Yes. Now, thereafter, my lords, an inquiry was held.
Giving defamatory statements in TV.
The
second charge is disorders of pursuit, behavior and physical assault on senior officer.
With due respect, lordship, without going to the permission, my lord senior, the limited issue is here. What is the scope of the conciliation officer under section 12?
That will come. That will come.
I will support two.
Yes. No. Please wait. Please wait.
Well, it can be remanded.
Your lordship, two judgments.
You are agreeable for remand?
No, lordship.
No.
That the conciliation officer has no power for adjudication. I have submitted two judgments.
No, these are not a question, my lord. So we'll see the impugned order. That will make it clear. Impugned order, Lordship will see that impugned order is Annexer 1, in WPC 1622 of 2015. Last maybe please submit one. Page 39 to 48. What the Assistant Labour Commissioner cum Conciliation Officer has given the finding while rejecting
33 2B.
2B, because Rashmi kindly peruse the reasoning of the learned Assistant Commissioner cum Conciliation Officer. Why he has rejected that application under section, the approval which was sought to be given by the Assistant Labour Commissioner.
Penalty order.
Penalty is dismissal from the service.
So approval for what?
Approval for when that is under the Industrial Dispute Act. Once the workman is dismissed, Rashmi grants may see the provision under section 33 2B. You have to take the approval from the Assistant Labour Commissioner. Now, the approval has to be rooted, has to be followed in the mandate as given under the statute. That is under the Orissa Industrial Rules. And you will also see section 2GI. Section 2GI of the ID Act, which says who is the employer. Because the employer has to
apply for.
Yes. Now the application which was filed by was not by the managing director, who is the employer.
Who had filed it?
He has filed the file. It was been by a manager administration. That was filed by manager administration. That is why the
is it what is that factory? Is it a company or what?
It is a power generation corporation.
Corporation. Statutory.
Yes, it is a statutory. It is a statutory.
Under which section? Under which section of which act?
And there is a government of Orissa PSU, government of Orissa company matter. It is amenable as a state under Article.
If it is a corporation established under a statute,
yes,
then sequences are different.
Matters.
If it is a government company as defined under section 617
of the Companies
Act,
yes,
consequences are different.
Correct.
It may be an instrumentality of the state.
Yes.
Under Sukadev Singh versus Bhagat Ram,
yes,
R.D. Shetty, etc.
Yeah.
Consequences will be different.
Correct.
If the statutory corporation,
yes,
the powers are earmarked,
yes,
who should exercise which power, then your contention is acceptable. If the manager of that particular department has power to apply for approval, courts have taken the wave, he also is an employer. Under 2GI.
So far as the power is concerned, which my lord has stated, he has no power, and to apply for the to take the approval from the labor commissioner or the conciliation officer for the approval. He has no power.
So 1 second.
Yes.
What do you say that power?
Power LOC has a glance to Rule 67(3).
Let us read 32(2)B.
Yes, 32(2).
1947. You have Orissa rules also?
Yes, yes. We have got the also Orissa rules.
Industrial dispute.
32(2)B.
33(2)B.
OLR
33(2). During the pendency.
1 second. My brother also wants this.
Yes, sir.
Why you are not keeping 2 books in the division bench? What is division bench?
A chat.
3(2)B. Yes. During the pendency of any such proceeding.
Yes.
Means any such proceeding means what?
Proceeding matters. A chatter of demands was already pending. May I place again the statute, that is 33(2), that I am placing matters. During the pendency of such proceeding in respect of an industrial dispute, the employer may, in accordance with the standing order applicable to a workman concerned in such dispute, for where there are no
such standing orders in accordance with the terms of the contract, whether express or implied between him and the workman. Then the next is after in regard to any matter alter in regard to the matter not connected with the dispute, the condition of service applicable to that workman immediately before the commencement of such proceeding, or any misconduct not connected with the dispute, discharge or punish, whether by dismissal or otherwise, that workman provided. So no such workman shall be discharged or dismissed unless he has been, that is for 1 month, and an application has been filed made by the employer to the authority before whom the proceeding is pending for approval of the action taken by the employer. So here, my lords, after
your contention is,
my lords,
the person who had sought for approval in terms of 33(2)(b),
yes,
was not the employer.
Not
the section uses the word employer.
Yes.
How this term is interpreted by various high courts in the country?
My lords.
Yes.
My lords, so far as yes,
O.P. Malhotra on industrial disputes act. Ask the librarian to bring it.
Now the lordship, may I be permitted also to place the order of the Assistant Commissioner, Labour Commissioner, who has given the reasons.
Given the approval.
Not given the approval. Rejected the approval.
Rejected the approval.
Yes.
That went in before the single judge.
Beg your pardon? That was remanded. That was, lordship will kindly see, they came to the High Court.
Yes, that is what
earlier. Copy of the order dated, lordship will kindly see, Annexure 9. Annexure 9.
As you rightly said in the beginning, matter lies in a narrow compass.
Yes.
Whether manager of the respondent is the management or the employer,
yes,
as contemplated under 33(2)(b)
of that provide
idea.
Yes.
Idea.
Yes.
That question, there are many judgments on that section.
Yes.
But give one judge one ruling in your favor.
Sir, with due respect to your lordship, the rule is clear. Your lordship has a glance to rule 67.
What is what it says?
Your lordship has a glance. Every application under sub-rule 1 or sub-rule 2 shall be verified at the foot of the employer making it, or by some other person proved to the satisfaction of the conciliation officer, board, labor court, tribunal, to be acquainted with the facts of the case. This is not the employer law.
Any person who knows all this, he can also do that.
And interestingly, my lordship client has raised this objection after 5.5 hours before the learned authority below. From the initial objection, your lordship is a glance to the first objection before the concerned authority.
Now, where have you convinced the conciliating, the concerned authority that you have full facts of the case? No authorization necessary.
Authorization was there. In the verification part, I have mentioned so, and the authority also accepted that. And being accepted, he has issued notice. The opposite party appeared, filed objection. He has not challenged the authenticity of the verificant.
In that objection, did he say that you are not a
lordship? That is not.
Lordship may kindly see page 120.
First objection. First objection.
No, in your objection.
Yes, I have
objected. Applications.
Milers, I have
take up the contentions.
Sir, may I?
Yes,
sir. May I, with great respect, milers, beg your lordships to see.
It's your right to argue.
Yes.
Yes. I am asking a question to you. Did you object to the application on the ground that he is neither the employer, which he is not, nor he has got authorization from the employer,
correct,
and that he knows all the facts and circumstances leading to passing of the order, and therefore he is making the application?
Yes, that is why I am requesting your lordship to come to page 120 of writ petition, where I have objected to it. Page 120.
This is on which date you objected?
I am during the time when the matter was remanded to the conciliation officer to decide the issue whether section 33(2)(b as per the direction of the High Court, when I was again adjudicating, when the authority was adjudicating, may I turn you?
One second.
Yes, yes.
What was the you debated before the learned single judge?
That was that they challenged the order.
What
Before the
order
High Court.
said?
Yes, Lordship may be pleased to see Annex 9 at page 70. 72, 73. The first round of litigation, page 70.
Ask the librarian to bring the book.
Send it to me. Send it.
I am placing that, my lords, that order at page 71. Just a minute. Our learned counsel for the parties, the order passed by the learned conciliation officer cum labor commissioner.
Whether the conciliation officer is the competent authority?
No, yes, yes. Yes, he is the approving authority, my lord. He is the approving authority because the charter of demand was pending before him. So therefore, my lords,
conciliation authority,
my lord,
does not have power to grant approval is the version of some high courts.
Yes, maybe.
Authority contemplated under 33(2)(b)(2) is the competent authority, not the conciliating officer. But the officer who is competent can also be a conciliating officer by notification by the government.
Yes.
He may have dual capacity.
Yes.
One is capacity as the conciliating officer.
Yes.
Another is the capacity as the competent authority under this provision.
Right.
Therefore, under their contention, see,
my lords, may I say something here, my lords? The High Court, they came to the High Court. It's an admitted fact. And the High Court directed again the same authority to consider it.
Which aspect do we consider? Where the judge
my lords, you will see that page, my lords, 71, it starts.
As on the day,
yes,
the order put in challenge in the petition.
Yes.
Had you taken up the contention?
Yes.
That the manager is not competent to apply for sanction.
My lords.
When, which date? What was the order date?
No, my lords.
Date of the order.
My lords, after the matter was remanded back.
You became wiser and you took that contention.
No, my lords.
Did you take up that contention at the earliest point of time?
Yes, yes. I think I have taken
No, you're not thinking.
Yes, no, my lords. Lords, you may see.
Expected 33C to give that some youngster can assist. Na? We will appreciate the order. We will come forward. Mr.
Mr. Mans.
Mr. Mans. Yes, just assist us. You are also party.
No. He is a
conciliation is not a party here.
Conciliation officer.
Just 33.
33(2)(b) and 33(a). There are two provisions under the ID Act 1947. 33(2)(b) speaks of that if at all any proceeding pending before the authority concerned seeks permission.
Without permission, you cannot do.
Yes.
Because section reads it.
Otherwise, all other disputes has to be referred under section 10. There are two provisions. 33(a) straight away one can approve. 33(2)(b) seek permission.
Reference by the government.
Yes, exactly.
Yes.
And another provision is 33(c)(2), wherein so far the computation of dues is concerned.
No, that is a
separate issue.
That is not. We are not concerned with that.
Yes.
Question is very crisp question. The contention is that the application seeking approval to the action of dismissal, that should be moved by the employer or a person who is in the know of all facts and circumstances, having authority, competence.
By the employer.
By the employer.
By them.
He can do that. Now he is saying, second, the incidental question is, can such a contention be taken up after the matter is remanded for consideration afresh?
It should be at the first instance.
That, my lords, I appraise your lordship, that I have objected to it.
At the earliest point of time.
Yes, that lordship may grant some days time.
But again, sir, you are a senior advocate.
Yes.
Generally, senior advocates should not seek time at all.
But the question which my lord
next
is...
Next week you will do that.
Next week.
And you have to do some research.
Yes.
We have very old Kopi Malhotra.
And there are another 2 editions are there.
In the identical issue.
Identical issue, there are judgments.
The conciliation officer has no power to adjudicate.
That's all. If he is holding the other capacity, suppose the government notifies the conciliation office. Government may notify the same authority as the conciliation officer and the competent authority also.
Here is no, with due respect to Lordship, here is
nothing like that.
Here the question was, because the management was going to take an action while the proceeding was being with the conciliatory authority and approval is required from the authority.
And you had applied.
Yes, you have applied for that.
You had applied for, to whom you had applied?
The conciliation officer.
And thereafter you challenge it saying that conciliation authority does not have power.
12, with due respect to Lordship, under section 12, the conciliation officer either to conciliate by the bipartite or tripartite manner.
That you did not seek. You sought approval. Then, having gone to that authority and having suffered an order at his hands, then challenging it, that generally jurisprudence does not agree. Because that will be, you are a mighty man, having funds, power, men, matter, material at your command. But employee is not, workman is not.
But 33.
You only went there.
The language is...
You only went there. And you say he has no power.
Yes, Lord.
33, my lord.
92 or 93 Supreme Court says, where the management goes before an authority and seeks some favor, and the authority does not favor, then it is not open to the management to challenge the order on the ground that the concerned authority is not the competent authority. Otherwise, they will be vexed. He's a tiny man. You are a mighty man. There will be no bargaining, equal bargaining power. Having gone to that authority and then having suffered an order, you contend, no, conciliating authority is not. Who asked you to go there? Statute did not say, go to the conciliation officer. But you went there. A statute said, go to the green forest. But you went to some other forest on your own. Maybe to trouble him. There are such judgments. In industrial law, what ought to be done, what ought not to be done, will have some relevance if the employer himself goes and seeks something to be done. Kopi Malhotra dedicates one particular 2-3 pages on that. Late edition, which Justice Indu Malhotra has dedicated. Look into it, come back.
And it normally also happens when a matter is referred to the industrial tribunal for adjudication. Preliminarily, you can also take up the matter under section 33(2)(b) for adjudication to see if the findings of the inquiry officer is proper or not. Is it or not? So that is an adjudicatory process. Here it is not the adjudication process. It is only an approval.
No, with due respect to Lordship, as per the constitutional judgment of the Hon'Ble Appeals Court reported in 2001, Supreme Court 2090.
Quasi judicial.
Quasi judicial, and the fairness of domestic inquiry has to be taken as a preliminary issue under section 33(2) application. And if it is
that's all right. But your contention that it is incompetent for the authority to that is not available.
Because he has no power to take evidence, he has no power to take exit.
You went there.
Because the statute says so. Because
therefore now you cannot take the contention that he has no power. You cannot blow hot and cold But you cannot approbate, reprobate. That is not allowed in industrial jurisprudence. Industrial jurisprudence, after we introduced socialistic, the word socialistic pursuant to 42nd Amendment, there is a leaning in favor of the employees, workmen.
Beneficiary piece of legislation.
There is a leaning. If you see the pattern of judgments on labor law, there is a shift in the approach of the court after the 42nd Amendment to the Constitution, which amended the preamble to the Constitution. Socialist, secular. Two words came to be introduced. So socialist has its own meaning. As you know, we don't say that communist, but socialist is enacted in the Constitution now. Therefore, there is a shift.
And in this case,
these aspects.
In this case, the workman has convicted in a criminal case also, arising out of same charge sheet.
Let us. Next time you should come with full preparation. Both sides should come with full preparation. No judgment will be granted.
May pray manners, can it be on Tuesday?
It's coming Tuesday. We are not sure because we have loaded the calendar with too many matters now.
It's all right then.
Can we have this matter on the 3rd of February?
3rd of February matters.
Yes. Kindly see your diary and tell. That
it's
4th of February. 3rd of February.
I beg pardon, Lords.
Yes, sir.
Can I make a prayer, Lords?
Yes, sir.
Item 8.
Item 8.
A small matrimonial orders. Lords, again the order of the Lord and single judge. Annexure 1 is the under challenge. Order of one single judge.
Yes.
Second annexure 2 is against the review. The stamp reporter pointed that you cannot make two prayers. Therefore, my humble prayer for Lordship, I do not press annexure 2, Lordship. That is the only defect pointed out by the...
No, even otherwise office may not be justified. That is on court fee. Court fee.
No court fee. Two orders I have challenged in the writ appeal. First, writ of the Lord single judge, and also the order of the Lord single judge on the review.
Yes.
The stamp reporter pointed out that you cannot make two prayers in a writ appeal. Therefore,
may not be correct. No, office may not be correct. You are entitled to maintain two prayers because one order is original order, another is review order. You are entitled.
Had you come only as a review probably.
That we don't understand.
the Lordship may allow defect may be removed. Defect may be removed. That is for that
ignore it.
The office objection is liable to be ignored since it is open to lay a challenge to the original order and the order in review in the same appeal. Okay.
Deeply obliged.
Yeah.
Item 11 has been adjourned. Item 12. Item 12.
Yeah.
No. Item number 12, my lord, I have filed an application being the respondent number 5 for vacation of the interim order.
But I have said the objection in the case, your lordship.
Main matter itself will hear.
Today also, my lord, I am ready.
My lord,
25 matter.
My lord,
For last 25 years, I have been dragging to the litigation. Stage they have lost.
My lord, Mr. Prafula Kumar Ratha is arguing this matter. Pray for next week, your lords. The first time it is listing. Pray for next week.
We'll have it on 4th of February.
My lord.
That day you have to argue.
My lord.
Your lords.
Yes, this is not registry. This is court.
This court.
Your lords. My lord.
Yes.
That no.
On 4th of February.
First time your lordship that is listing. That's why the last chance.
Finally. At the request of learned counsel appearing for the respondents.
I am
appealant.
For the appellant.
I have already supplied the
because there is a stay order.
Yes, my lord. For last 35
we have
years, my
agreed
lord.
with you. We have agreed with you. We have passed the order. Still you will argue.
No.
But I am supplying the copy, your lordship. Objection?
What I should do like that? If you supply and have the signature and post violating the regime. What all you have done now? What we should do with that?
Interim past also continue.
If we wanted to continue till the 4th of February.
Yes.
Item 14.
Item 14 will
This is now squarely covered by Bafna Motors judgment. The Supreme Court says once the sales certificate is issued.
Bafna is the surfacey.
Yes, Lords. Lords, what has happened here? I was the auction purchaser. I deposited the entire amount. The borrower did not cooperate. They did not leave the vacant.
That was the appellant.
Yeah, I am the petitioner, my lords.
No, here.
Yes, I am the petitioner.
May I, your
They
lordship?
should argue.
Lords, I am the petitioner. They are not.
Auction purchaser.
They are not vacating the premises and not giving the premises after even sale certificate has been issued.
So who is the petitioner?
I am the petitioner, my lords. I am the auction purchaser. I am.
No, what happened last occasion? I have taken. I have submitted before your lordship that I will take notice for the son who has been substituted for opposite partner of court matter. But in fact, I have taken instruction from my client that there is a dispute between son and father after death of the mother. For that reason, he is not able to. I am not in a position to appear for the opposite partner for. For the notice should have been issued to opposite partner form in this case, my lord.
Will issue police notice to OP number 4.
No, he is at America.
America. Then we will pass order.
Yes,
we need not wait for.
Yes.
In this
because
case,
no, he's a co-borrower also. The husband is a co-borrower.
In this case, advocate for OP number 1 and 2, let it come next week, my lord, is father-in-law expired, my lord.
Way back when? 20 to 30 days ago.
Opposite party bank, my lord, husband cooperative bank. One and 2.
Who is that?
On behalf, item 14.
Oh, who is appearing for that?
Jajati Mahanti, my lord. Father-in-law expired, my lord.
On 5th of February, be ready. Yes, brother, we'll have it on 5th of February. In the meanwhile, can you send a notice by mail?
He not two things. I don't have his mail ID.
You furnished the mail ID.
He is not contact with he also told me outside the court that on that number because there is a dispute within father, so he knows before me also.
I am supposed to know because you are not delivering the property.
No, it is not the
now. Who is owning?
It is the sale is not the proposed sale because after death of the wife, the sale has been made. After realizing the sale, bank has taken the entire amount from me along with the interest money.
That is not. That is once sale certificate is issued in my favor. The Supreme Court has said Bafna Motors says they have no right.
It will be considered in 17 if my friend is saying that.
No 17 millions. The judgment is crystal clear.
Is very clear.
Yes,
it goes against.
Yes.
It goes against you because the sale is not a proportional because by that time the wife died. The notice is not been served on that day.
For that, the remedy you should have worked out elsewhere.
Yes. The remedy lies in
that has been dismissed. That has been dismissed. The remedy has been dismissed. That DRP has dismissed the application.
They moved in 3rd day.
Yes. The DRP dismissed the application. But the order is at face bill of Miss C. I am just putting Miss C page number.
Also on that my lord.
No, please, 31. Let us see 31. Let us see, understand what is the situation.
No, not necessary.
I am not there, my lord.
But the question is, so if we pass order without service of notice to the other side, it runs the risk of setting aside at the hands of the
I have to take it through the council. Consular, my lords. Consular. Because that may be directed, because that will be based very differently. Father is not
yes, petitioner to take consular service of service of notice on OP number 4A. Who is stated.
I'm sorry, Lord, objection will be disturbing in the orders when orders being disturbed. Lord, he's a co-borrower also.
That's not, but you have arrayed.
Now, Lord,
what do you give up?
Yes, the abatement. Okay, I bow down.
Therefore, consular service of notice on OP number 4A.
Yes, why? Because he passed away in the meanwhile, so it will be 4A.
Who is stated to be residing abroad.
We don't know the address. We'll try to also get from the consular only.
First off. Posted immediately after service. Yes.
Item 15 has been added. Item 16.
Date immediately fixed.
Immediately after service.
Okay.
Immediately after service.
I am running from here.
That's the only problem. But we have said immediately after service we can.
Yes, much. I will service.
16, my lord, my opposite parties have filed an affidavit, served a copy of the affidavit. So my prayer for lordship only to 20th. I'll left to 20th.
28.
20th?
20th. This put in date. Tuesday.
No, 28 is Wednesday.
20th. 20th.
We have difficulty.
20.
Okay, call on 20th at the request of. Six are posted. On that day, we have posted 6 matters. On 20th. 24, I have it on 21st. 22nd, we have issued. 22nd, we are sitting single. 21st, because I posted.
20 must have.
Arrested with each. Wonderful. 21st. Yes.
Item 17. 17, my lord, say contempt application, my lord. It based on dispute of since 24/9/2024.
My lord, pursuant to lordship's last direction, we have taken effective steps for compliance of the order. Now it is on the verge of compliance, my lord. And we have to make payment. There is no dispute about it, only official procedure.
Several dates they have taken urgently. Last order is lots of glance. Land has been acquired since
Panda is saying something in your view.
Your lordship have a glance towards past order sheet, my lord. They have taken several.
That your lordship may see the IA, we have filed annexer A by 5 and annexer B by 5, page number 8 and 9, flag B, your lordship may see.
When the order was made?
Order 24/9/2024.
Sorry, 24/9/2024. 2024. What was the order?
Order to disburse the compensation.
Show that.
It's page 12. Annexure 1, page 12 and 13. You will say a glance.
Page 12.
Para 6.
Page of the above, we dispose of the petition with the direction to opposite party, more particularly so and so.
4 and 5.
To disperse the compensation amount as expeditiously as possible, which in a period of 2 months from the date of production of that order shall be. No, will issue arrest warrant.
No, lordship may see the last order.
Yes.
27/11/2025. Order number 6.
What it says?
It says, well, after due verification and discussion, the committee approved the compensation. The copy of the proceeding is taken on record. That part of your lordship's record now. Your counsel for the state seeks further time to obtain instruction in the matter. It is on the verge of compliance, my lord. We are proceeding for compliance.
The lordship have a glance towards past order sheet.
The case for arrest.
Past order sheet only.
See the
24/9/2024.
No, your lordship. We are seeking extension of time for that. IA number we have filed, seeking extension of time, reasonable time. Only for 4 weeks time we will comply with the order. Lordship, see the annexure.
Last occasion they have also taken
So your lordship, 2 letters have been letter have been issued.
Only 70% of land.
Sit down.
My lordship, see 8 and 9. Your lordship kindly consider the annexure A by 5 and B by 5 of the IA. Flag B.
No, for more than 1 year, 4 months, nothing has been done.
No.
What is the guarantee that they will be able to?
Lordship can have a perusal. A by 5, B by 6 after the lordship's order only.
No.
We have taken because the government funds have to be allocated, my lord. Funds have to be allocated and we have moved before the appropriate quarter.
Only
your lordship may see.
4 weeks. Since counsel for the complainant is
Sorry,
yes, call after 4 weeks. Yes.
Extremely sorry, my lord.
No. Yes, call.
Extremely sorry, my lord.